Hello and welcome to today's hybrid event, The Future of Renewable Energy Investment in Europe, Europe's Obligation to Pay Renewable Energy Awards. My name is Dave Keating. I'm coming to you live from the Euractiv studio in the heart of the EU quarter. Welcome to all of you watching us online and to all of you here in the room. Today we're going to be talking about the obligations the national governments face when they change energy policies, something that has until now been governed, among other things, by the 1992 Energy Charter Treaty. Now, you may have heard of this treaty in the news recently because it's been controversial and also because a number of EU countries and now the EU itself have walked away from it. Now, energy projects, including modern renewable energy installations, require substantial upfront investment, as well as complicated permitting and licensing procedures in order to get off the ground. And 30 years ago, it was decided that an agreement should be made to give investors more certainty in these projects. That 1992 timing is no accident. The treaty was actually meant to encourage Western investment into the struggling energy systems of the former communist countries, which were badly in need of renewal and investment in the early 1990s. The treaty provided for international arbitration through the World Bank ICSID Court. However, earlier this year, the EU signaled its intent to leave the treaty following decisions already taken by several of its member states to leave. Critics of the ECT said it was preventing countries from implementing the energy transition needed to meet the EU's climate targets because companies and investors were using it to sue because of the cancellation of new fossil fuel projects or existing fossil fuel projects. Essentially, they were saying that the ECT was locking governments into fossil fuels because it meant that they couldn't change their minds. But leaving the ECT could also have an impact on the confidence in renewable energy projects, because when it comes to the type of energy, the ECT doesn't discriminate. And that's what we're going to be talking about today. And as an example, we'll be discussing the controversial topic of Spain's Renewable Energy Awards. So the Spanish government introduced incentives in the mid-2000s to attract investors in renewable energy projects, which led to a significant expansion of the solar industry in Spain. Over 66,000 families and solar companies pledged $70 billion into the incentive, ensuring that Spain reached the EU target of 20% renewable energy early in 2010, way before any other European country. However, the economic downturn of the late 2000s prompted the Spanish government to reevaluate its energy policies. And as part of the economic austerity measures of the government introduced at the time, Spain introduced a series of regulatory changes that reversed the subsidies and feed-in tariffs that they had promised. They also introduced new taxes and imposed caps on renewable energy production. The investors in those projects, understandably, protested, saying the changes are retroactive and they violated Spain's commitments under international investment treaties. 50 complaints about this have been registered with the ICSID, most of them brought under the Energy Charter Treaty or various bilateral investment treaties that Spain has with certain countries. Spain argues that the awards were state aid and therefore not payable because of a change. And this is where the European Union comes in. Because if the European Commission decides to retroactively declare these awards as state aid, it could have a major impact on the cases. Now, this is just one example of how leaving the ECT could have a big impact on investor confidence and also leave a kind of black hole that needs to be filled in terms of investor guarantees. What is the ECT going to be replaced with? And how will EU renewable energy investors be protected? We've got a panel of legal experts and investors here with us today to discuss the implications. Let me introduce you to them now. We have here with us Nick Cherry, who has represented a number of people affected by that Spanish change, investors into those projects over the years, and is an expert in international disputes. We have Lena Sandberg, who is a partner with K&L Gates in antitrust competition and trade regulation. Prior to joining that firm, Lena served as a partner at the Brussels law firm of Gibson Dunn, and her experience covers all aspects of competition law, including state aid, abuse of dominant position cartels, and merger filings. Then online, we have David Gomez, who is CEO of Grupo Iberoca, a major Spanish renewable company. David is the principal investor for the Mexican Gomez Saints family, which has been involved in renewable energy since 1994 rather. Iberoca invested over 100 million euros in Spanish solar in 2007 through the Renergy SARL, and now holds a 33 million euro award against Spain for the retroactive withdrawal of renewable premiums. And then finally, we have Thomas Hopp, General Counsel for the Ariam Group. Ariam was the first renewable energy investment company to offer professionally structured investments into Spanish solar. They started out with private placements and then continued with classic closed-end funds for retail investors, so also obviously quite affected by the issue we're going to be talking about. Thank you all for joining us here today. Now, you at home and those of you here in the room will be able to ask your questions to the panelists using the Slido feature. If you're watching online, you can see the space there for where you can enter your questions. I will read those questions out to the panelists at the end of our discussion. Also, if you're here online, you can scan that QR code, type in your question. You can go ahead and start putting those questions in now if you already know what they are, and I will read them out to the panelists at the end. So, Nick, let me start with a question for you. As I mentioned, you've been representing the people affected by this decision. What is the current status of the legal cases around the loss of Spanish Renewable Awards, and how has the EU's decision to pull out of the Energy Charter Treaty impacted this issue?
Great, thank you. Thank you for that. I'd like to put a little bit of flesh on the bones of what we're talking about to sort of drive it home as a matter of reality. So multiple investors have been prejudiced by the change of policy by the Spanish government. And those investors brought multiple claims against the Kingdom of Spain by way of various treaty proceedings, arbitration proceedings. There are over 50 of those claims. Approximately half of them have been decided finally, and they've been decided against the Kingdom of Spain, i.e. the Kingdom of Spain unlawfully acted against the interests of the investors and caused those investors harm. The tribunals in those different arbitrations gave various decisions called awards in favor of the investors. The total value of those awards now is nearly $2 billion, with interest accruing all the time. Those awards are now final and done and dusted. I've been leading an enforcement campaign in various jurisdictions around the world, trying to get Spain to pay the bills. We've seized assets of Spain in various different countries, in particular in England. Nonetheless, Spain refuses to respect those awards and refuses to pay the bill. Why? Well, that essentially is for political reasons. Spain has decided it doesn't want to pay these things and has said it's not going to pay them. Now, that's a very unfortunate position because Spain was a party to the Energy Charter Treaty and various other international treaties, under which it accepted an international obligation to honor the terms of those treaties and to compensate investors if they get harmed. Spain is refusing to honor the terms of those treaties. So what Spain is doing is refusing to honor or respect the international rule of law. That's a real problem. And Spain is in such a bad position in this regard that I think it's second after Venezuela in terms of non-compliance with international treaty awards. So it's not a good look for any country. In particular, it's not a good look for a leading member of the European Union. So that's where we are legally, and that's Spain's resolute position. Unfortunately, the problem has become even more acute this year. Why? Well, Teresa Rera was a member of the government of Spain for many, many years, and in fact was in charge of the climate policy. She has said openly that she is against the payment of these awards, and that has been her position consistently for many, many years. That is unfortunate, certainly from the perspective of the investors, who are, of course, not getting paid the money they have been held to be due by international tribunals. Teresa Rera has been nominated for a key role within the European Commission, essentially in charge of climate policy and in charge of competition. Her portfolio, therefore, will cover precisely the problem that we're talking about. So we have somebody who was apparently ideologically, philosophically, politically extremely aligned with a particular point of view against the payment of awards, notwithstanding the international law position. She has now got a key position she is being proposed for a key position within the Commission, where she will get to decide issues in relation to the payment of these awards. This is an acute problem because, as I'm sure most people will be aware, anyone who's nominated for a position such as a commissioner within the Commission must be and must seem to be independent. They must have no conflicts of interest, and they mustn't have the perception of having any conflicts of interest. That's not just a matter of common sense, there's actually fundamental rules of natural justice and law. The real concern that the investors have is that she isn't independent and doesn't appear to be independent and won't therefore be independent in her decision making when it comes to considering issues relating to competition and state aid, all sorts of issues that affect the ongoing enforcement of these awards. Now, that's a real problem. It's actually made somewhat worse by some of the associations of her husband, who has also had has had an official role within Spain involving competition and related issues. So the problem of conflict of interest gets a little bit deeper as well and compounds the perception that things shouldn't be as they are. One solution to that problem is that she either recuses herself. She steps aside, assuming she is ultimately successfully becomes the commissioner. She steps aside from anything to do with renewable awards, in particular renewable awards against Spain, and whether they can be enforced or should be enforced, or those kinds of things. That would be, of course, the right thing to do and an elegant and appropriate solution to the situation that we have. So that's where we stand today. It's a very unfortunate position. The investors are very pragmatic. I can't speak for all of them, but I know that they're keen to see a commercial, practical resolution to the issue in relation to the payment of these debts. Nobody wants to keep spending, well, certainly not on the investors' side. They don't want to keep spending money on lawyers and dragging this on for years. Real companies who have shareholders who are ordinary people have lost a lot of money through what's occurred, and they're very happy to see a practical commercial resolution. And we know that the European Union would prefer to see this problem resolved, not least because this is just distracting from other things, but also, as we're going to hear, this has undermined and does undermine investors' confidence in renewable projects going forward. And we all know how acutely important renewable energy is for the world, in particular for Europe. And it's sad to note, the unfortunate events in northern Spain very recently with the torrential rain and the tragedy that's caused. I was reading only this morning how meteorologists and experts are saying, unfortunately that might become more common, in particular in Spain, because of climatic change. Well, the only way to, as we know, to fix or try to address the climate issues is to invest wholeheartedly and full bore in renewable energy. Unfortunately, and again, it's a sad irony, the attitude of Spain undermines the confidence of investors in investing in projects going forward. So that's where we are today. The legal fights carry on. We've got courts in Australia, Washington, DC, London, very senior courts, all deciding in favor of the investors as a matter of international law. But unfortunately, Spain is still stuck in the mud and refusing to engage and to honor its debts.
Well, Lena, we've just heard there some of the EU connections here. What's your view on these legal cases, and how has the EU or could the EU be involved?
Yeah, let me take a few steps back. You very eloquently explained the situation and how it arose in Spain. But in order to understand it, particularly from the investor's perspective, I think it's very useful to just walk through what happened at the time. At the time, at the end of the 90s, the EU badly wanted a transition to renewable energy. So bad that it asked all the member states to support it. And I mean, here we're talking at a time when we didn't know whether the windmills could spin or the solar panels absorb the sun. There was no one with real knowledge about whether this technology could work. Therefore, it was also clear that if you wanted this to take off the ground, you had to give subsidies. So, 2 steps back, the EU does not just ask companies to invest or the member states to focus on renewables, but it also asks the member state to offer subsidies on that basis. The problem was, of course, entrenched by the fact that when you sell renewable electricity at the energy exchange, you will only get the market price. And the market price still is set by fossil fuels, much cheaper, and therefore the need for subsidies was even further entrenched. That meant that most member states in the EU actually did give subsidies. Amongst that, it was also Spain. The trick was that these subsidy schemes were based on the fact that when you get subsidies through, should we say, every time you sell your electricity at the market, at the energy exchange, you need a subsidy every time you sell it. So the need for subsidies was there all along through the lifetime of the plant. It's not enough you get in the beginning or in the middle, you need to have it until the plant has been amortized. Spain was amongst those countries that introduced a subsidy scheme precisely on that basis. They're commonly known as feed-in tariffs or, have similar nicknames. Then halfway through, after having offered these subsidies to many investors that only invested on the premise that they would actually get these subsidies, halfway through the lifetime of these plants, Spain stops it all and says, I'm going to cut the subsidies to less than 50%. As a result, as you can imagine, many of these companies would not get the profit or any profit, and if they would get a profit, it would certainly be too small that it would have invested in the first place had they known that this was going to happen. As has been explained, companies then sought for compensation for damages. I mean, what else to do? You have invested, as we will hear, retirees' money, family money, etc. So you naturally seek for getting some of those money back. They did so relying on the Energy Charter Treaty. The Energy Charter Treaty has been signed by the EU itself, including all member states. So you would say that's a pretty reliable base to rely on for the purposes of getting damages. It worked. At least in 27 out of 50 plus cases, the investors have won. They're getting their compensation for damages, at least on paper. Because then the Commission turned around and said, you know what, those awards representing compensation for damages for you, you can't keep them because we think they are illegal state aid. Investors turn around. So how exactly is that? This is compensation for something I did. I invested, I lost. Now I'm supposed to get something for the fact that I lost for a promise that you did not keep. No, says the EU. It is not, because the fact that the decision has been adopted by arbitration tribunals means that we can't trust it. We don't think it's valid. So why is it not valid? Well, it's not valid because arbitration tribunals do not constitute part of the EU court system, i.e. arbitration tribunals do not report to the European Court of Justice or the General Court in Luxembourg. Therefore, arbitration tribunals are not accepted, and whatever decision they issue, we consider invalid. And therefore, that effectively means that the money that these companies get paid out are considered as a bag of money paid for no reason. And as most people will know, state aid in the EU is prohibited, and therefore they said, you can't have that money. If to the extent you've gotten them, you have to repay them. But this is not just a problem for the investors and the EU. This is an international problem. I mean, many of these investors doesn't even come from the EU. They come from outside the EU. And many of them do not understand how the EU rules can apply to compensation for damages that have been issued to investors sitting in Japan or the US or Australia or elsewhere. So at the end of the day, it is a question of the EU as an institution and also those platforms that were engaged in order to obtain the arbitration decisions, such as ICSID, UNCITRAL, huge international platforms to which more than 160 members across the globe confided in terms of having a peaceful way to settle disputes. You would then think, isn't that then a problem for these institutions to sort out? Here we are in a situation where, for some reasons, we think that EU law clash with the results that international law gives us. Mind you, this is, I said, a situation where the EU itself signed up to the Energy Charter Treaty, and I would say almost all members of the EU are members of these international platforms. I'm saying that because right now we have a new mandate of the Commission. We have a new, I'm not going to say a new president, but at least she has a new mandate. Ursula von der Leyen has said several times that under her new mandate, she will do exactly what the Draghi report told her to do, namely to attract investments. In plain words, Draghi said, we're doing pretty much everything right here in Europe, but we're not so good at attracting investments. She picked on that and said, I will therefore make it my most important task. Even Ribera, as we have just heard now, who is in charge of competition, is in charge of attracting investments in renewables. Now, if we take 2 steps back and look at these investors that believed that they could invest in renewables at a time when the EU asked them to do so, and now the EU is saying, I'm sorry, you can't have compensation for the lost investments that they made in the belief of what the EU said. Where are we then now with Ursula von der Leyen's request of having increased investments? Would you think that those investors would be inclined to invest now in Europe? Because what? Because they're treating them as if they are welcome here, and that if there are problems, then we support them? That's not the message that this case is sending. I leave the floor here because I think we can hear more from
the investors.
Our investors.
Exactly, yeah. So thanks, Lena. Let's turn now to the investors on the panel to get more of their perspective. David, I'll turn to you next. For Iberdrola, what has been the impact of Spain's decision to pull the renewable energy awards on investment? What has that experience been for the investors?
Well, it's of course been a terrible experience. It's had a huge impact on Iberdrola. Which was funded by our family money, family office, based mostly on ideological, and of course we wanted to make the world a better place. We knew there were very big risks when we invested, very big technological risks, because the windmills were new, but I mean, we assumed those risks. I'm an engineer. We didn't know if the windmills would last 10 years or 20, but we did it anyway because we thought it was the right thing to do. We were not aware that there was any regulatory risk because we believed what the government told us, that the feed-in tariff was guaranteed for the life of the installation. So we assumed the technological risk, which was very high in itself. We thought there was zero regulatory risk. So we decided to invest heavily in these projects. And we managed to pull it off. We managed to install very nice wind farms, which are producing electricity, and solar farms. But this legislatory change in 2013, where they ripped apart all the money, or half of the money that these installations made, almost made them worthless, because of course these projects get financed with banks. So we defaulted on banks. We barely had enough money to pay the banks. We need to refinance everything. And pretty much all of the energy that these installations are going to produce during its lifetime are going to, all the earnings are going to be to pay the bank an interest. And pretty much, as far as shareholder value goes, it's pretty much zero, because we're probably not going to be able to give ourselves any dividends ever on these projects. So all the capital that we invested, which is close to 100 million, is pretty much lost. So of course, understandably, we filed a claim with ICSID. We won the award, and of course, we were surprised when Spain did the regulatory change. We were double or twice surprised when the European Commission was saying or telling Spain that this was state aid and that it could not pay it could not pay these awards. I don't know if this is a political thing or if they talk between Spain and the Commission or why did this arise. But of course, it's been a grueling process. It's been hard to build these projects. It's been hard to fight in court, more than 10 years for these projects. And it's been even harder to lose a huge amount of the family money that we earned during many tens of years, from back to my father and beyond that. So of course, I mean, I'm hearing every time I hear that the European Union wants to attract investment. I'm kind of thinking, well, they should talk to investors because I don't know how much or what advisors they have to attract investment if they don't know the basic things about businesses and risks and of course having a nice regulatory framework for these projects to be, or for investors to actually invest in this project. So I mean, if they think that that investors are going to risk their money and their investors' money in a system where there's no way of trying to settle any discrepancies or any issues or any legal issues that arise, a system that is independent. It's like trying to invest in a government where the politics own the judiciary system, and basically everything is what the politics legislate and take a decision. There's no way to react against that because the judges are also belong. There's no separation of powers. The judges do whatever the politicians say. So you need in order to invest, first you need a fair system. You need a fair dispute resolution system that does not depend on the legislative or the executive, and of course you need the executive or any promise that has been made or any contract that has been signed to be to be respected and to be done. There's no, who would invest in a country where they can change the rules at any given moment and they can take away or expropriate? It's pretty much just an expropriation. For me, it's no different than Venezuela expropriating a factory from a family. For me, it's exactly the same thing, because the result is the same and it originates from the same place, which is in the laws or the legislation or the executive of that country. And this, I know that this debate is centered on renewables, but this applies for everything. This applies for any type of innovation. If the European Union wants to keep innovating or wants to be at the forefront of innovation, it cannot. It needs to provide an environment for investors to be happy to invest their money and safe to invest their money in, because there are so many countries right now, everywhere in the world, where you can that are fostering innovation, that have fair systems, that is attracting all the talent, all the money, and all the intelligent people to invest. So this is a competition. Europe is not doing a good job, in my opinion, at creating a good environment for innovation, and that's why Europe is not getting investments in innovation. And I'm sorry to be harsh here with my words, but this is how I feel, and this is the truth that I've learned. I was naive back in 1999 when I thought there was no regulatory risk by investing in these projects. As a matter of fact, now I'm not. Right now, if you ask me, there's a double regulatory risk. You have the risk of Spain and you have the risk of the European Commission. And if those two risks don't have a fair system or don't make a good environment for investors, it's going to be very hard for Europe to get innovation and get investment in innovation, because it's just a minefield compared to other countries. And that's the way I feel, to be honest.
Thanks. Yeah, we'll come back to this issue of how the investor confidence climate here compares to some other regions in the world in the discussion. But Thomas, I wanted to get your perspective as well. So David was just telling us that although they were aware of technological risk, they weren't told about any regulatory risk when they made these investments in Spain. Was that a similar experience for Ariane? What was the experience for you guys in terms of the Spanish change of policy and then the subsequent legal battles?
Yeah, thank you for that question, Dave. David was speaking out of my heart, so to speak. We started investing in Spain in 2008, and for the ECT case that we were involved in, we invested early 2010. Total amount of 128 million euros, 35 million euros equity from our investors. We knew the technology, we invested in solar, the technology should work. No one had an idea how long it will work and to what percentage. So it was a risky investment. And as Lena was already mentioning, it's the sale of energy. You need to make a certain price to yield result from your investment, and the market price was much below that yield that you needed for solar. When we started in 2008, 1 megawatt of solar installation costed 6 million euros. Now we are talking about 600,000 for 1 megawatt. And that's a great result. That's exactly what was supposed to happen. A lot of people invest in solar, the scale-up effect, the prices go down, the megawatts go up. Super, perfect. But then came Spain. Not only in 2013, by the way, but they started beginning of 2011 to change things. 2013 was total chaos, what they did. They cut the remuneration by 30 to 50% at the end of the day. Our investors, which are not high net worth individuals, they are teachers, there's a garbage man, an investor in our company. They put in their pension money in our hands to invest in Spain. And we did so because Spain was saying, hey, if you come to Spain, you'll get a fixed feed-in tariff for 25 years for the power that you sell. Sounds good. It's the sun, you can calculate how much sun you will have. So if the hardware complies, everything works out nice. And Spain is a respectable country in the EU. So we invested the monies in Spain, and then Spain turned around and said, no, sorry, was a mistake. We started with the ECT case, sued Spain for 80-something million in damages in 2015, and we were awarded 41 million euros in 2019. We asked Spain, when can we talk about the payment mechanism? They never replied. We asked again, they never replied. We asked our lawyers to talk to Spain. They never replied. So now some 4,000 investors who have invested 35 million euros. They wait for damage compensation of by now 50 million euros. We have invested in Spain. If we had known that they turn around on their promise, certainly not. Could you have invested in Spain if you knew that they would turn around? No, because the structuring of the investment is a key part. If someone tells you'll get remuneration for X years for the product that you're producing, then you can do the math and you know how much money can I invest, what is my return. If Spain would have said, I can only pay you 15 years prior to the investment, that might have worked out. But you can't change from 25 years X amount of remuneration to less years and less money. That just doesn't work in the economics. And as David was saying, that's the big part that the EU seems to miss when they're asking themselves, why are there no investors?
Maybe we can zoom out a bit here. And just a reminder to the audience, again, you can ask your questions on Slido, and I'll ask them to our panelists later on. Lena, we've been talking about the Spanish case, but I wonder, are there other similar cases here where there were sudden policy shifts happening in other countries that companies and investors were then looking to the ECT or other mechanisms to try to have redressed?
Thank you for that question, Dave. Yes, indeed there are. So the Spanish renewables case is a big, important case because of the many investors that invested and because of the values lost and the amount of money that is now at stake for compensation for damages. But it's not the only place. The exact same principle is being implemented elsewhere in the EU. And one case in point, which is interesting for a number of aspects, is the Mikula case. Essentially, two brothers residing in Sweden decided to invest in Romania in the food sector. Because in Romania, they were giving certain tax incentives for various investments in a particular region. So they did that in the belief and on the premise that they would get these subsidies. And then a similar situation as in Spain, Romania, halfway through, decided that these tax incentives should no longer be in place and repealed them. And the investors, the Mikula brothers, were in the exact same situation as our Spanish investors. They made use of the fact that there was a treaty between Romania and Sweden that allowed investors to take Romania before an arbitration tribunal and ask them for damages because of their investment also had become unprofitable. Same thing happened. The arbitration tribunal awarded the brothers damages for their loss. And then the commission turned around, exactly as it did in the Spanish cases, and said, I'm sorry, you can't keep that money because that is state aid. But it did one thing more. It didn't stop there. It said, you have, to the extent that you've received that money, and the brothers had received some of that money, it was not enough that that money is being paid by the companies, but it held personally the two owners of these companies liable for repaying state aid. I don't know how many of you know something about competition law, but one of the things that you always have to pass in competition law is that it only applies to companies. So we're leaving the very basic principle that competition rules only apply to companies to a situation of state aid where you have extended the liability to repay the aid not just to the companies and the parent companies, etc., but to the shareholders themselves. That means that these two brothers are liable for, I don't know, a couple, 200 million with their personal assets, with their pensions, with their cars and televisions and whatever else they may have, which is, of course, way too far. And that shows you that it's not just a question of ensuring that awards, arbitration tribunals cannot issue awards that are not in the court hierarchy of the EU. This case has gone much further and become, I would almost say, a personal pursuit of companies that have invested in the belief that they could use arbitration tribunals as their dispute settlement mechanism.
Well, Nick, you've been involved in a lot of these types of cases. Are you also seeing other cases like this? And also, have there been lessons learned from the Spanish case? I mean, is this something that's still being repeated now?
Yeah, sadly, yes. So if you like, tier one countries, I'm going to say United States, most European countries, if there are claims against them, they resolve them. They pay their debts. A lot of African states, South American countries, sort of various rogue nations, they tend not to pay their debts. And despite the fact that there are these mechanisms out there, these international treaties, bilateral investment treaties, the Energy Charter Treaty is designed to protect people that invest in countries, and nations sign up to them. Unfortunately, there's quite a few nations that just don't honor their debts, and they don't respect the rule of law. The Energy Charter Treaty is administered by ICSID, which is set up by the World Bank. There's a whole sort of global infrastructure set up under the auspices of the UN, that was all basically set up to resolve and to address investment needs and concerns, to encourage people to invest in countries that might be a bit shaky and there's regime change and stuff happens. That's why these treaties have been so incredibly useful and valuable. But as we've been hearing, not only does it take an awfully long time, if a country changes regime and a new president comes in or a new party comes in and they rip up the old rules, the tariffs, yes, you can go to arbitration, you can bring a claim. It takes years and years to resolve it. It costs millions and millions of dollars, and an awful lot of patience and management diversion, all that kind of stuff. And you win. You get your bit of paper. You win some damages. And trust me, this is not America where you get billions of dollars for punitive damages. You're lucky if you get you get something back, and then you find that the sovereign refuses to pay. The sovereign has another ace in its hand, which is something called sovereign immunity. Sovereign assets, as a general rule, are immune from execution. So it makes it doubly hard for investors, claimants such as the ones against Spain, to actually seize any assets that Spain may have around the world. If those assets are commercial assets, it's less difficult. So there are numerous hurdles, if you like, that mean that the card is, the deck is stacked in favor of the sovereign. And unfortunately, some sovereigns, deliberately take advantage of that. And some, unfortunately, we got Spain for whatever, I'm afraid it's ideological, it's philosophical, it's political. There's a deep-seated sort of zealotry about the payment of these awards, which is just bizarre. It's just bizarre. We heard, really helpfully from the people that are actually being impacted by these decisions. And, it is a tragedy, it is a scandal, and it infects the investor community's attitude to investing in countries, not just Spain, but beyond Spain, because it kind of sets a precedent. If Spain's doing that, well, why don't we do that? Venezuela and some other sort of historically rogue nations, Argentina, well, they've always been a bit problematic, right? But you've got tier one countries not behaving, not playing by the rules of the game. What kind of precedent does that set? And this is, here we are, 21st century, where respect for the rule of international law has never been more important. The need for renewable investment, people to take commercial risk, has never been more important. And yet, we have this unfortunate position. Lena's just described what's going on with another particular case. There's a very unfortunate feature that's developing out of the Mikula case as to what on earth is going on here. This is not profiteering. This is not punitive damages territory. This is people who've been harmed, having the harm adjudicated upon, and a sensible measure of damages being awarded. You pay your debts. It's rather like respecting the outcome of an election. Somebody's going to win, somebody's going to lose. But whatever the decision is, you respect it, you comply, and you get on with your business. Unfortunately, we're in a very different world when it comes to Spain.
And elsewhere, I suppose. David, you had mentioned before the concerns about competitiveness, as Lena had mentioned the Draghi report, which was specifically on Europe's competitiveness issues. When we're looking at Europe as opposed to other areas of the globe, the US, where we have the IRA giving subsidies in the form of tax breaks, which look relatively secure. You had the BRICS summit last month, where there's a lot of talk about new investments being made. How is the loss of the ECT going to impact Europe's competitiveness in terms of attracting investment in energy projects when you look at those other areas of the globe?
Well, yeah, that's why I said before. If you remove a fair judgment system or a fair dispute resolution system, and you just leave everything in hands of the commission or the politicians, that means, we know how the system works now. Of course, any given policy, they can give it a name and they can call it what it is, and they can justify it as many ways as they can. They can say this is, they can call it aid, they can call it, innovation, incentives. They can call it whatever name they want. And if they call it aid, it looks worse. If they call it innovation incentives, it looks better. So it depends who's in charge. They're going to give it a different name. In the end, it's the same thing. It's support for innovation. That's what it is. So if you have on one side an investor trying to invest in a place where whatever support he is being given can be taken away or changed name to something that looks worse or sounds worse, and then politically they can screw you over, and you have nowhere where you can try to resolve your disputes, nowhere independent. You have to resolve it with the same person that's taking away your support. Then it makes it very hard to invest. No one in their right mind would invest in a system like that, to be honest, especially other people's money or investors' money. I wouldn't, for sure, because I have a bit of common sense, and most investors do have a little bit of common sense. So other countries do have systems to resolve the issues that not only can recover the investment of the investor if there's wrong having done to it, but also it gives extra compensation, not just recover what you lost. It gives you extra compensation in order to dissuade anyone from trying to mess with the support that has been promised. And these are the type of assurances that investors need and want to invest. They say, look, okay, I'm investing in a safe place. I have if the system goes against me, I have a way to reclaim back my investment, even if I spend 10 years. And of course, I'm going to get an extra compensation because of all my time and all my suffering that I've done. So this makes it a little bit more worthwhile to invest in this place. In the end, it's a worldwide competition for innovation. The countries that get the innovation, in my opinion, are going to get all the success and all the investment and all the and better quality of living, and they're going to be richer countries than the companies that try to curtail innovation or try to break their promises to investors. It goes nowhere, to be honest, if they do that.
Thomas, given that there is a worldwide competition for innovation and for investment, how do you expect the loss of the ECT to impact Europe's competitiveness in terms of attracting investment, particularly when you're contrasting it to the situation in the US, situation in the BRICS?
At the end of the day, the ECT is just a contract. If someone being party to that contract wants to leave the contract, then that's it. Obviously, Spain and probably Italy in the near future do not honor the ECT contract, so it's of no use furthermore. What I'm concerned with is the message that is sent out. The message that we are not honoring contracts. We are not honoring our promises. What else is not being honored in the future? If you want investors, as David was saying, and you make a trade. You give money for something. The country should participate in by taxes, whatever, and you get a return of your investment. And the riskier the return, the riskier the investment is, the higher the return is. So it's just a matter of mathematics. If investors consider Europe for an renewable investment, and with the new green program that we are pursuing in Europe, we need fresh investments, because it's, again, like in the early 2000s, like solar and wind, it's a new energy stage or new technical stage that we are entering. It's a high-risk investment, and you either support it or you don't. That's very, very clear answer. If you don't support it, there will be no investment in it, at least in Europe, probably in other countries. And then again, Europe will trail behind. So the ECT is a symptom, but not the solution.
Nick, I mentioned at the beginning that the criticism of the ECT and the reason why many countries were looking to back out of it for political reasons was that it was felt that it was tying countries to fossil fuel investments when they wanted to change their mind because of the EU's climate targets. What has been the response to those people who were calling for countries to pull out of the ECT, calling for the EU to pull out of the ECT, to cases like this, where it's actually impacted clean investments, renewable energy investments? Has there been some rethinking about that, or rethinking about what might need to replace it?
Yeah. Well, it throws up a number of issues. One is, how does that any country withdrawing from the Energy Charter Treaty or other bilateral investment treaties, how does that affect the existing claims or even claims that might be filed tomorrow? The answer is it shouldn't do, because there are just various provisions in those treaties called sunset clauses that mean that people can still bring claims. So it actually doesn't, as a legal matter, does not affect the existing claims that we've been talking about. So that's clear. I think from a soft political point of view, atmospheric point of view, I think, again, a country like Spain thinks, well, we're withdrawing from the ECT, therefore we don't have to comply. Unfortunately, I think it sort of compounds the thinking from a soft political point of view, even and a hard political point of view, that we're out of the ECT, we don't have to comply with our obligations. We should never have entered into it in the first place. It was all a mistake and all that kind of stuff. So that's not helpful. There is discussion, to some degree, at the UN at least, regarding what can replace the mechanisms that people are resiling from, but there's absolutely no immediate prospect of anything coming into play anytime soon. So again, we go back to what we hear from so eloquently from the actual non-lawyers, the actual investors, that you're left with a lot of uncertainty, and it's not just going to affect European countries, it's going to affect other countries in the world, because what are the dispute resolution mechanisms that are going to exist in the event that there's a regime change, and all the risk that people have taken that they're left completely exposed, because these mechanisms have gone to resolve things internationally and hold the state liable if there is a regime change and they do some bad stuff. There is no answer at the moment as to what could replace. There's a lot of discussion, but it took years to negotiate the ECT. These things take, as you can imagine, sovereigns all around the world have to agree to these things, all sorts of policy issues and da-da-da-da. I mean, one of the issues we have, unfortunately, coming back to what Lena's talking about in particular, unfortunately, there's been this sort of view in Europe that European law is in some way superior to international law, and that's the view we're taking, and we don't have to comply with our international obligations. Which goes contrary to so many historical legal principles and contrary to the treaties that everyone signed up to, which is very unfortunate. So put it politely or neutrally, there's an impasse regarding what might replace what people are walking away from. So that's where we are with that.
You wanted to come in?
I think it's worthwhile just entrenching that. I mean, you have a treaty that the EU signed up to. Now, if it now, 20 years after, 30 years after, thinks that it could not sign up to that treaty, what exactly is it that it could not sign up to? Oh, it says it could not sign up to the fact that you could arbitrate between a state and an investor in the EU. Well, if it was so that that was law 30 years back when it signed the treaty, why then did it sign the treaty? I mean, so let's assume it was not law at that time, or at least it was not clear to itself that it was law, or it was not clear to the investors, that's for sure, and everybody else. Then either you don't sign the treaty, or you sign the treaty and admit you signed the treaty, and then later on say, I made a mistake. Okay, I made a mistake. Then you correct it for the future. And everybody's clear on that. Everybody understands now ECT is no longer to be there, and we're going to find a different solution. Well, we'll see if we find one. But at least that's clear for the future. But for the past, you cannot undo the past. You cannot just step out. I mean, it would correspond to, everybody knows the Inflation Reduction Act, right? Everybody knows how many investments were made on that basis. Could you imagine now the US would just turn around and say, you know what, I made a mistake. I'm just going to take that money back, I'm going to take it back. And then what are the investors going to do? They're going to go before courts, or they're going to go before arbitration tribunals, exactly like they did here. They're going to get some damages, and the US is going to say, no, I'm sorry, can't have that money. You can't have that money. Why can I not have it? I invested in the belief that Inflation Reduction Act was going to, pay me the subsidies. It's the exact same thing, except the US didn't do it. Now we are in the EU, and they did it. So it's not, it's not interesting to enter into a legal discussion about whether the principle that the EU does not like arbitration tribunals and between the states and the investors. It does not. Okay, clear. But you did not say that. At least you did not say it when you signed the treaty. So we are caught in this dilemma where we can say correct for the future and believe what we want to believe for the future, but we have to find a solution for the past so that investors that believed when the EU said, please invest in renewables because we badly need to have an energy transition here, and we will give you subsidies. We support that member states are giving subsidies. And how can you not feel trapped as an investor when everybody invited you to do so, as Thomas has so clearly explained, at a time when nobody knew what they were doing? So they asked all the investors to take the risk, and then now, when we have the renewables and everything, the cost has come down, we turn around and say, so sorry, we made a mistake, and you can't have those investments, you can't have compensation for it. And at the same time, please invest in hydrogen, please, please, because we need this now. That's the type of situation we're in. So it's not that we won or investors are against developments in EU law. That's how it is. And we all subscribe to judgments of the European courts, etc. Nobody wants to live in a lawless state. That's not the discussion we're having. The discussion we're having is, can you turn back the clock? And most people would say no.
David, I know you have to leave shortly, so I want to get one last question to you. And we've referenced already the kind of unusual situation we have now with Teresa Rera, the nominated commissioner from Spain, who has been involved with these cases. Now, unusually, the climate portfolio and the competition portfolios have been combined in this new von der Leyen term. That was not the case in the previous term. It was the digital and competition portfolios that were combined under an executive vice president. So weirdly, she has the two very issues that are combined in this case. And of course, as we mentioned, there are several instances of things like this, but Spain is kind of the biggest money and the most prominent one. Do you think that if she is confirmed, she has a confirmation hearing next week, but if she is confirmed as Executive Vice President for Climate and Competition, that Teresa Rera should recuse herself from any decisions involving these cases?
Oh yeah, completely do. Definitely. I mean, the problem here is that we're at the mercy of the ideology of the people that are leading the commission or the laws that affect us. So the problem is that a person has a very, very clear ideology, then it's always going to act in that direction, and maybe and not just and maybe against the higher benefit or the higher good of the whole European Union. Maybe that person has her personal ideology, and maybe she's acting in favor of her ideology, but against the rest of Europe. So we have to be very careful who gets the power and how they act on it. And if someone, of course, is not impartial on something, it is very dangerous because, of course, it can have huge negative consequences on Europe if that person is not being impartial.
Well, thanks, David, for joining us today. I know you have to hurry off, but thank you so much for being with us. Thomas, I wanted to put this question to you as well. So what would actually be the impact of Teresa Rera's competition department deigning this in hindsight as state aid? How would that practically impact the ongoing cases?
For those investors who had the luck to receive some monies out of their case, they would have to repay it. And as Lena was explaining with the Mikula brothers, it would put the shareholders probably in dangers even, which from my point of view would be very unpractical and unhealthy. It's such a bizarre thought, actually, to declare it as the award state aid. I mean, I've been on that case, on our case, for what, 8-9 years, and I still can't comprehend the magnitude of the change in politics, in attitude that we've witnessed. I mean, in the early 2000s, the Green Deal was everywhere. We all wanted to be good. And now we have people leading Europe, making decisions for the investors, or the presumed investors, I should say, because I don't see many investors coming to Europe, how they have to structure their investment, how they are supposed to be the good guys. And if you don't follow that doctrine, you're not the good guy anymore. And the mental state and the mental direction this all goes is very worrying for me. And also as just a private citizen of the European Union, I'm very pro-Europe and I'm pro-green, but the state-driven attitude that we see is something that I remember from East Europe some 30 years ago. And if they, for no reason, grab into your pocket as being an investor, that's not a good answer.
That was the genesis of the reason for the ECT in the first place. Nick, can you walk us through what difference it makes if this is deemed state aid, and what kind of conversations are happening with the Commission right now on this?
Well, actually, I might defer to Lena, who is far more expert in the Commission than I am. But certainly speaking as an international disputes lawyer outside of Europe, I think the position that Europe has taken on legal issues is not one that the courts around the world are agreeing with. Unanimously, the courts around the world, I mentioned Washington, England, Australia, are all of the same voice, that whatever the legal arguments are that Spain has raised and keeps repeating and keeps repeating and keeps repeating like a stuck record, the courts around the world, do not find favour with those arguments, and including the state aid argument. It just doesn't wash. It just doesn't wash. That's the attitude of the courts around the world. But Lena, do you want to talk about the Commission?
Yeah, I mean, it's clear that we're talking about 50 plus cases, and for sure 26, 27 of them have been notified by Spain now, interestingly enough, arguing that the state aid that they themselves claim is state aid is violating the competition rules. This is unheard of. When you notify state aid as a state, you say that please authorize my state aid. But here they're notifying it saying please prohibit it, which is means that the system is, of course, not cut out for a situation that we have here. But the bottom line is that what we see is that, I would say, thankfully, the Commission is putting a little bit of the foot on the brake in the sense that there are no negative state aid decisions in the situation of Spanish renewables. There are just none. And out here on the other side, we perceive that as a positive message, although, I mean, the cases date back now 3, 4, 5 years. So you could easily make a problem out of that. But we have no interest in doing that. Everybody wants to use this as an occasion to find an amicable solution between not just, you say, investors and the EU, but between the EU and other big institutions like ICSID and UNCITRAL, who represent companies across the globe that have subscribed to peaceful settlement mechanisms. So if those, I would say, high-level democratic value-based institutions could come together and work out a solution for the benefit of us all, I would say, that covers the past period, and then we can all move forward with no ECT and whatever else will come, and the basis of the judgment that has now been issued. I'm saying this from a point of view that nobody wants to break the law. Everybody wants to stay on the right side of the law. We all trust that we live in a state of law. And with such an amicable solution, I think everybody would have more faith that we are indeed a state of law and that we try to find solutions in cases where where things didn't work out the way that the institutions thought they were going to, such as this situation.
Well, let's take some questions that have come in from the audience. Again, you can put your questions into Slido. I'll receive them here on the tablet and then ask them to the panelists. First question is from Diana Powers. Lena, I'll put this to you again, since I think you're the most connected here. So the question is, this discussion adds a new dimension to business calls for policy stability, though it is usually omitted from such discussions. How much awareness of this problem is there in policy discussions at the European level?
I would say pretty much none for the moment. That's one of the reasons why we're sitting here. I think that part of the job with these type of cases is to explain them, and explain them from an honest point of view. Nobody is here to hang people out or institutions out, but it is to present a problem that have occurred through, I would say, the fact that we have developed, the renewables have developed, the fact that energy, the EU wants an energy transition, the fact that we established international institutions worldwide to resolve disputes between states and investors. All of these factors are now, all of these factors have brought us to a situation where it has become clear we need to find a solution to this. And in order to do that, we need to inform everybody and tell them about these cases. Of course, all the investors are aware of them taking place, including in Romania, and I would also say there are also a set of Italian cases going on with the exact same mantra. So part of this event is exactly to inform people about this is the situation, and I would say also inform people like Ursula von der Leyen, who is going to run this new mandate in the name of attracting investments for renewables.
Yeah, Thomas, you were referring before to a kind of obstinacy that you're feeling from policymakers. So in discussions with policymakers at European level or national level, how much awareness do you think there is of these types of issues of investor uncertainty? And are you getting this impression that for this type of situation in particular, people just hear, oh, investors, bad, renewables, good, and so if they're trying to get money, it must be contrary to renewables in some way?
It depends very much, I believe, on the situation that you talk to people. If it's in public, it's usually they are very set back with what they actually think. It's much more about the line of politics that they are in, that they perceive people want to hear from them. There are certainly some politicians and some high-level folks who do not understand the full magnitude of the issue. They should, but they probably don't. But then again, there are a lot of people who fully understand the problems, but just say, "Hey, it's politics. I'm bound. I can't do something. Don't know why. My party is against it. It's not opportune at the moment to speak up in this direction and to name things that should be named." I mean, if I may, we are the lucky ones. At least we do have a title. We can talk to the EU, to Spain. The ECT only applies to extraterrestrials, to non-Spanish organizations and people. And I mean, in 2005, the Spain real estate market blew up. A lot of the construction companies went into solar and started constructing solar farms. They employed thousands of people. And I know at least a dozen companies that didn't survive the retroactive changes because all their project developments was just from one day to another zero worth. And they lost their jobs. The companies went into insolvency. It was a big mistake, I think. And they don't have a title. There is no claim in Spain that I'm aware of in the national court system that won.
Nick, what's your thought on whether policymakers are really aware of this as an issue?
I think internationally they're extremely aware. I think people in the World Bank and the UN are very concerned. I mean, the international legal framework that most of us operate in, us lawyers anyway, and other international businessmen take advantage of, are acutely concerned about it, very concerned about it. And it's really unfortunate to be saying, Spain's number 2 after Venezuela. I mean, that's just it's not a good place to be. It means that the international community is not functioning as everybody thought it should, right? And sorts of bad stuff going on in the world, people breaching other treaties in much more physical ways, and we're saying, no, you need to respect the rule of law. Well, a little bit hypocritical, isn't it? So internationally, it's a major issue. I know the dispute resolution centers around the world are concerned about this. There's only so much we can do. We can, keep trying to persuade people in positions of power in Spain, positions of power in the Commission to change their thinking and come up with a practical resolution, which is all we want to achieve here. That's all we want to achieve is a practical resolution. I mean, it's almost unheard of for laws to be retrospective. They just aren't. As a matter of principle, laws are prospective. You don't go back and rewrite laws from 20 years ago, 30 years ago. That's contrary to all principles of natural justice. But that's, as Lena was saying, that's essentially what's going on here. And that's concerning. That's a precedent.
But you could mention some of the cases that were in the US that has been won by investors. I mean, because apparently US courts do not share the opinion of the EU, etc. UK courts.
Well, I mentioned them en passant, but the Washington D.C. There's several cases where there's a big appeal court case decided in favour of the investors and dismissed the arguments of Spain. We've had an appeal court decision last month from England. Again, Spain lost the first time round, appealed to the Court of Appeal in London. London dismissed the appeal by Spain. It went up, similar appeals in Australia, went up 3 levels to their Supreme Court. Spain lost at every level. I mean, that's the view of the international community. And these are these are proper, serious judges in big, serious courts where things are fully argued. So it's really troubling. It's really, really troubling internationally what's going on.
And actually, there's an interesting case that has followed because of that. So the UK, one of the UK courts ordered the enforcement of the award, saying that we need to uphold the arbitration decision, etc. And then the European Commission took the UK court to before the European courts, saying that the UK court was wrong. This was after Brexit, so you would at least argue that there would be no competence for the EU courts to say that. But it's just to show that this is, as Nick is saying, it's become a fight even between the courts.
Well, the next question is something I was curious about myself, actually. This will be a question for Thomas. It's from Jan Ahak. Would the investors in the cases mentioned for the non-payment of awards at this point be ready to settle for the repayment of the original investment, or is the end goal also damages in the amount of possible profits? And it relates to another thing I was wondering. We have gone through, I believe 3 governments since in the whole array of this saga, right? The conservative conservative left. The current Spanish government is not the one that took the austerity decisions to cancel. If the current government said, okay, we're going to go back and honor the original, which was from their own party, the original promises, would that be enough? Or what might be acceptable in terms of fixing this?
I mean, I would be happy if they would start talking to us anyway. The court decided the arbitration award with a very classical discounted cash flow method. They took the time of investment and then they looked at the time of infringement, so to speak, and looked what the investment was worth at each time, and then did a discounted cash flow. That's how they derived, or the financial experts derived the amount of damage that we can claim. If Spain would reinstate the old remuneration, as of now going forward, can't do the math in my head now, but it would be nice, but I don't think it would work out so well. So preferably, I mean, just make a reasonable offer.
Because of the loss of the possible profits in the meantime, right? Because there would have been a big gap.
Yes, and it's the profit in the meantime. I mean, our investors have never had €1 out of that investment. That's the first. We were unlucky enough that we had a lot of cash, but obviously our financing contract with two big German banks for the long-term financing, that was in jeopardy. We lost 30-40% of our annual turnover. We were just living out of the cash that we had accumulated, paying back to the banks, but it was foreseeable that in the second part of 2018, the company would go cash bankrupt. So on last we saw, because in 2015 and 14 we were doing relatively good. We were the last to be restructured, and we got a cutthroat restructuring offer. It includes cash sweep, so still no money for the investors. All receivables go to the bank, and that until 2030 something, whenever we'll have repaid the money, and then the plant is some 27 years old, and it's hard to believe that there will be any significant energy production will go on. So we take every compensation that we get offered, for sure. It's the court evaluation is one evaluation. They found that the measures implemented at 2013 and later were incompatible with the ECT, not the previous ones. That's a decision I can respect. It would be nice if you don't get totally ignored by the state and basically sabotaged by your own country.
Nick, generally speaking, are the investors looking for repayment of the original investment or the amount of possible profits?
I think generally speaking, as Thomas was saying, any form of constructive engagement would be good with Spain. Moving on from that, it's already been floated, the idea of some alternative way of compensating investors, maybe some kind of a renewable bond could be put in place that investors can take advantage of. But any way to compromise things from a practical perspective, people would be very happy. Whilst we have seized various assets, it takes a lot of time and it costs a lot of money to do it, but investors collectively have got the resources to do that, and they will continue to do that. But the investors want a practical resolution. I mean, this is a huge distraction for people like Thomas and David, and larger investors as well. And the lack of any substantive engagement to resolve things is, putting it mildly, frustrating, I know, for the clients. And commercially and practically seemed a little crazy to me that, this needs to be resolved. And the investors, I know would be very pragmatic as to what the solutions can be, and the door is open, absolutely on the investor side, to try to resolve this in a sensible way. I'm a great believer in the phrase "peace with honor," right? Peace with honor is what no one's looking to sort of have some huge, Pyrrhic victory. I mean, that's just silly. We should all get on, come to a sensible deal, and move on with our lives, and promote, the well-being of the EU and the investor climate.
Well, here's an interesting question. I'll see who wants to answer this, who might know. The question is from Diana Powers. The question is, as I recall, Germany had to pay a couple of billion to Vattenfall when it stopped its nuclear program. Do traditional energy sources fare better in these disputes than renewable energy? So Germany's sudden policy shift on nuclear, I think, somewhat resembles Spain's sudden policy shift on on solar specifically. Who would like to take that?
She's absolutely right. This is a perfect example where the Commission did not, first of all, I don't think there was a difference between renewables and fossil fuels, but I do believe that there was a difference between the Commission's behavior until 2018, when it, from the European courts, were handed a judgment that would tell it that arbitration between states and companies in the EU does not work. And the evidence is that Why was it possible for Germany to pay Vattenfall in a completely similar situation? Just the fact that it involves a different member state and a different company doesn't change the scenario. What was going on in that situation is exactly the same as in the Spanish renewables, as in the Romanian case, as in Italy. So why then did they not pursue it there? Because it was a little bit too early. It hadn't really formed its view yet. It wasn't clear yet. I mean, it also relied on the Energy Charter Treaty. As I said, the EU signed the treaty. And no one said to Germany, you can't pay that money. Or to Vattenfall, you have to repay the money because this is illegal arbitration. No. And the only tree they have to crawl into is that it was ultimately settled. But settled why? It was settled because there was an arbitration proceeding against Germany. And in the absence of a settlement, of course, Germany would have had to pay. And, well, in the absence of the Commission coming after them, Germany would have paid and walked away. And we would be in the situation where all the Spanish renewables, in principle, should also be, at least on the basis of the Energy Charter Treaty. So, yes, good example.
I want to underscore, maybe I'm being a bit lawyery. I hope if I am, tell me to shut up. But the curious feature I find about this whole dispute is, weirdly, Spain changed the tariffs, right, wrongly, and people suffered harm. That's a wrong. And that's been decided multiple times that was wrong. What seems to be the real issue that Spain and other European countries have taken is they don't like the dispute resolution mechanism that was used, namely international arbitrations outside of the EU. And that's their big point. And that's the big European point. Is that, well, we may have signed up to all those treaties that provided for dispute resolution mechanisms, like literally a mechanism, you know, a body of people appointed to sit in something called international arbitration, on an international arbitration tribunal that's divorced from the European courts. That's procedure, that's form. And that's the big problem that people in Europe have had, people in Spain. And they don't like the fact that the problem was solved that way. So it's what I find, so therefore, particularly unmeritorious, another particular point about the position of Europe and the position of Spain and Italy and some other countries, is that they don't actually now really dispute that they did any wrong. They don't actually dispute that. They did change the tariffs. People did suffer harm. It's a fact. It's clear. They may have argued it initially, which they're entitled to, but they've lost. Their real argument is that they don't like the way that things were decided. So I just want to underscore that because it's even more unmeritorious, the position that's being taken. And this is, again, why are they doing that? Why are they doing that? Isn't that strange? If you've done something wrong to somebody and somebody decides it, shouldn't you just, pay your bill? Yes. Oh, no, we don't like the way that it was decided. It's something called form over substance. So it's just unfortunate for all the reasons that we've already underlined. But actually stepping back from it, so why is Spain taking this position? Because of the way that Europe, certain people in Europe don't like the idea that things get decided outside of Europe. That's kind of it, which is ideological.
Thomas, do you have thoughts on the difference between the Germany and nuclear decision and the Spain and renewables decision?
No, they are exactly the same. That's why the ECT is there. Germany, the government decided on the spot to leave nuclear energy. They can do that, and they have to pay for it. That's basically the taxpayers. I pay for it, and I can't hold my government responsible for it because it might have been a dumb decision, as we see now. We don't know. It's totally the same case, and it's the right judgment at the end of the day, and it shows that it doesn't discriminate one form of energy over the other. It's just energy and investment. That's it.
So that, steal the floor again. Absolutely, it doesn't really matter it doesn't matter at all whether it's renewable, whether it's fossil fuels, whether it's any form of investment, whatever it may be, building a medical plant. It doesn't matter. Energy Charter Treaty, I appreciate, is focused on energy, but the general principle here applies that's an issue applies across multiple bilateral and multilateral treaties, these investment treaties. It doesn't matter what the investment is. There's an ideological issue that's taken by Europe and by Spain and others that we just don't like the way that things have been done and what we signed up to. We just don't like it anymore, so bye-bye.
When it is against the state.
When it's against the state, you're right, when it's against the state, yeah.
And that maybe is the case in point, because everybody that went and used the national courts, these old Spanish investors, they could not rely on the Energy Charter Treaty because that's only for investors that are from outside of Spain. Yeah. But all the Spanish investors could not do that, so they had to go to the Spanish courts. And of course, the Spanish courts, I wouldn't just say that this is in Spain, but in most places, the national courts side with the state, because they are immensely patient of the state. So all the Spanish investors did, of course, not get anything from using the national courts. And that is precisely why the Energy Charter Treaty prescribes arbitration, because states don't like to be taken to court. Obviously not. So that's why you have arbitrators deciding on disputes between them instead of the courts. That's the whole underlying reasoning for the Energy Charter Treaty, because otherwise you don't need it. You just go to national courts and problem is fixed. But precisely because investors said, well, I don't think I can really trust that the national courts would side with me over the state. That's why you have the arbitration.
Well, we're just about out of time, so I want to use the last audience question as a kind of wrap-up question, because it's very forward-looking. The question is from Raili Kajaste. Hope I'm pronouncing that correctly. The question is, a breach of a long-term contract with early investors on wind and solar power cannot be accepted. How can we put this issue forward to the new EU Commission so that these kinds of incidents do not harm in the future early investors? So I'll go through each of you in terms of looking ahead. How do we prevent this in the future? Nick, what would you say?
Well, actually doing precisely what we're doing now. I mean, again, I feel sorry for the investors. They're the kind of like, they're the vehicle through which these issues and arguments are being put forward. But, in a sense, we're all trying to persuade those of us sitting here and others who are on this side of things. We're trying to persuade the policy makers to acknowledge that there's a problem and to help fix it. And that's the best that we can do. It's called conversation, it's called dialogue, it's called argument in the best sense of the word. There's no polemic here. We're trying to use the art of sensible persuasion and commercial reality and pragmatism to achieve, hopefully, the right end, which is good for everybody.
I would say, if we say now that this judgment, the famous judgment Achmea, it's called, which basically from an EU point of view bans arbitration by investors against the state, if we say we have to live by that judgment, because that's now the new law we have to live by, what can we then do? Well, perhaps what we could do, because this was the problem of the courts, they said, but these arbitration tribunals, they do not form part of the court hierarchy in the EU, and they don't report to the top level, which is the European courts. Wouldn't there be a way, perhaps, where these arbitration tribunals could report to the European courts? Wouldn't there be a way that we could integrate them in the court system? With the belief, I'm not saying this is the solution, I'm just saying, wouldn't that be a way to be explored so that we could still continue to have arbitration tribunals set up against member states, but in a way that they are integrated into the EU court system so that they comply with this newer judgment?
Thomas?
As on my professional eye, I would enlist Nick and Lena to support me. They are doing great jobs on such things. As a private person, I would say talk to your politicians and try to get educated. I'm not saying don't trust your press coverage, but be critical. There's always an angle on coverage like on these topics, and if you're not aware of the different arguments and the different angles this discussion can have, you have a problem, because you're not able to understand the impacts it has right and left, and that is, I think, very important. So go and get educated on the things and speak to your politicians. In Germany, we are desperately lost on speaking to our politicians. They were just shoving us away. It was ridiculous. And we tried to tell that our investors, they wrote themselves to our politicians, and they got no answer back. But at the end of the day, they are the elected representatives. So find the representative that you agree with.
Well, I want to thank all of our panelists for some really interesting insights on this, which is a complex issue, but I think we were able to kind of break it down very well. So how about a round of applause for our panelists? And thank you to all of you at home and here in the room who joined us for this discussion. As we've just heard, this will be something to watch both for these particular cases, but I think also for this as a general issue as the EU walks away from the ECT. It does have a long lead time, as was mentioned, to actually leave, but eventually some kind of replacement is going to have to be thought up. So thank you so much for you at home for spending your afternoon with us, and for those of you in the room, we can talk more outside these doors. Take care.
Thank you. Thank you.